real pleasure to be here. I've been doing some speaking. In fact, I just came from Case Western talking about the Iraqi High Tribunal, another interesting attempt at justice in a place far, far away. And so it's a real pleasure to be here. I have an extensive speaking schedule, so I was kind of kidding my good friend John Barrett. I said, is this Saturday? And he said, yes. And so it must be blowing green. So I got in late last night. A wonderful new colleague was so gracious to come and drive all the way over from here to Cleveland to come pick me up, and we had a pleasant conversation. So Ben, thank you very much for your courtesy. It was very, very nice of you. It is important that we pause on occasions like this because, again, at the 60th anniversary of the judgments at Nuremberg, it is critical that we think about where we're going with international criminal justice. It's just a simple fact that we are not a perfect situation, and as we discussed, and maybe even discussed yesterday, we have the jurisprudence, we have the tools, we have the International Criminal Court, we have a hybrid international war crimes tribunal model that appears to be working, or could be used to complement the ICC, and yet they give us the authority, they give us the mission, we start, we get about halfway through, and they're no longer interested in where the rest of this is going. And it's a huge problem. In fact, in my mind, and we'll talk more about this hopefully in the question and answer period, in my mind, it's politics, politics, politics. If the international community chooses not to allow us to do our job, in whatever capacity that may be, from turning over a key indictee that has been lawfully indicted and lawfully issued an arrest warrant, to just not giving us any more money. That is on the shoulders of the so-called international community. And I think that is practically the biggest threat to international criminal justice. And that is just that. It is really a major problem. I think from a legacy point of view, and we can certainly chat more about this as well in the question and answer period, but the biggest challenge to the wonderful legacy that was left by people like my good friend Henry King is just this, and I'll put it right out front and we can talk. And that is the loss of the moral high ground in the United States of America is its biggest challenge to the legacy. We no longer have any standing to look people in the eye and say, we follow the rule of law. I'll be glad to chat with you about that extensively now and for the rest of the morning.
I'm probably one of the only one of my colleagues who have gone outside the green zone there, and that was at the beginning of the trial, because now it's quite dangerous to do that. And for my Iraqi colleagues, although some I must admit live outside of that, I'm talking about either the Iraqi lawyers who now live outside the country and must fly in with myself and my colleagues when we go into the court. And I've talked to people who support the former president of Iraq, Saddam Hussein, people who violently oppose him. And both categories of people, the one thing they agree on is that this trial is a public show and a farce. Those who oppose the president think that's a good thing because it means he'll get executed more quickly. Those who support him believe that there's nothing they can do about it and it will merely serve as an inspiration to their opposition to the occupation. So certainly these are emotional aspects of understanding what justice is. But I would suggest that the definition of justice provided by Article 14, for example, of the International Covenant of Civil and Political Rights, the definition of justice provided by Article 14 of the International Covenant of Civil and Political Rights, which is ratified by over 150 countries, is a definition of justice that all of us can understand, and that should serve as the basic understanding of justice. If you don't allow, as has happened before the Iraqi tribunal, the defense to see any of the evidence that could be exculpatory, not even to see any of the relevant evidence. As you may know, the first trial, the Dejul trial, concerns an attempted assassination of the president, a trial or legal proceeding that took place afterwards, which the basis of the accusations are that that was an unfair trial, and these people were summarily executed afterwards. Because it was a fair trial, they were executed in accordance with law, and many countries, including the United States, provide the penalty of execution for treason, which is what they were charged with, essentially. We have never seen the proceedings of that trial. You may have seen that the judge who was on trial, who presided over that trial, said, "Give me the papers from the trial and I'll show you that it was a fair trial." The Americans said to us, interestingly, not the Iraqi tribunal, the tribunal said, "We can't get the papers." The Americans said to us, "We have the papers, but we're not going to give them to you." We never visited the site where they claimed these alleged crimes took place. We asked before the trial started. We weren't allowed to visit. And as you know, in that trial, we were given the charges about 30 minutes before, after the prosecution had 8 months to provide their prosecution case. They showed up in court. They said, "Here are the charges." The judge read them out. And they said, "Now start calling your witnesses." That's not appropriate time and facilities to prepare a defense. These are only a few examples. As we provided the court a brief of over 125 pages detailing, and not much law. It was not a memorandum of law. It was more equivalent to a petition in a federal court here, where we just set out in the most basic way the violations of due process. About 40 different violations of due process. And if you count up the possible violations, that's about all there can be in this trial. And I think when you have that degree of unfairness in a trial, you have injustice.
Yeah, because the people who have that view say, well, we have lofty goals and ideals, we never do that, or if we do it, we call it something else, and we have a good reason for it. It's them, it's those others who are different from us who do it, so who cares about them? But if we bring it back to we're all us, and if you happen to be accused of a crime such as that or any crime, would you believe you would have a fair opportunity unless you had these specific protections? Then I think people think of it differently. So I think it's an us and them. And I also think we have to look at two aspects. Does the statute or the other legislation or laws which create the court set out sufficient protections for a fair trial? And as my colleague said, Article 14 of the International Covenant of Civil and Political Rights sets out minimum guarantees for a fair trial. And in fact, when the Yugoslav Tribunal was created, the Secretary General wrote a report accompanying the statute. And in that report, he said it is very important that the basic guarantees for a fair trial be provided to persons accused of these crimes at every stage of the proceeding, and they are best embodied in Article 14 of the International Covenant of Civil and Political Rights. So does the instrument creating the court set those out? But as we discussed yesterday, the law can be great. Do you actually implement them in practice? And if we look at the Iraqi Special Tribunal statute, it does embody principles and language from both the Nuremberg Ad Hoc Tribunal and the International Criminal Court statutes. How well are they actually being implemented? I think that's the issue that my colleague is facing in this trial.
Thank you.